As some of you may be aware, that Bar Council of the Maldives will be launching a national mooting competition by next year. A discussion meeting has been already held with all the law schools to discuss targets, expectations, and identify areas of collaborations. We note that while the idea of a national competition was well received and highly appreciated, local law schools had noted the importance of additional support to provide skills training to law students. We are happy to note that we are now working towards the implementation of targeted students workshop to develop mock trial and oral advocacy program for law students. We are grateful to our main partner, U.S. Department of Justice, for supporting the development and implementation of the activities under this program. We are confident that we will continue to work on mutual areas of interest, and we will continue to develop legal and justice sector of the Maldives. We must also note that to take this opportunity to appreciate the fact that we are also joined by the Prosecutor General of the Maldives, Al-Ustaz Hussein Shamim, who is also the first distinguished speaker for this evening. I'll now introduce the speakers for this evening. Al-Ustaz Hussein Shamim is the fourth Prosecutor General of the Maldives and was the second member staff appointed to work with the first Prosecutor General, Al-Ustaz Ahmad Muiz. Additionally, he was the first Deputy Prosecutor General. He was appointed to the said position on 4th February 2009. Prior to his appointment for the position, Al-Ustaz Shamim undertook the position of President of the Family Protection Authority. He was also practicing law as a defense attorney. Al-Ustaz Shamim was sworn in as a practicing lawyer in 2004. He started his legal service as an assistant state attorney at the Attorney General's office. He undertook further employment as Deputy Director of the Attorney General's office, member of the Employment Tribunal, Senior Assistant Public Prosecutor at the PG office, and Deputy Prosecutor General on 2 separate occasions. A notable legal service rendered by Al-Ustaz Shamim was the assessment of newly passed Constitution of Maldives in 2008 and drafting of the legal advice presented to the President by the Attorney General prior to the ratification of the Constitution. Further, he was also the lead consultant of the project undertaken by the Attorney General's Office and UNDP to prepare for the implementation of the project of the new Penal Code of Maldives. He directly oversaw the formulation of the training programs conducted regarding the awareness of the new Penal Code, amending the Penal Code, and preparing materials such as newsletters. Al-Ustaz Shamim completed his first degree at the renowned Al-Azhar University, Egypt, in the field of Shariah and Law. Also, he completed a master's degree in criminal law and criminal justice from the University of Sussex upon receipt of Shariah scholarship awarded by the Government of the United Kingdom. Right after Al-Ustaz Shamim's lecture will be followed by a lecture from Ms. Yi-Ting Wu, who is currently the resident legal advisor to the Maldives. Prior to her current appointment, Ms. Wu served as an Assistant United States Attorney in the Terrorism and Violent Crimes Unit of the United States Attorney's Office for the Western District of Washington in Seattle, Washington. Ms. Wu earned her Juris Doctorate and a Master's in Social Work at Washington University in 1990. Ms. Wu has been a federal prosecutor for 27 years and handled a wide variety of prosecutions, including domestic terrorism, hate crimes, cybercrime threats to federal officials, human trafficking, child exploitation, money laundering, financial fraud, explosive devices and firearms, murder and felony assaults, and transnational drug crimes. Ms. Wu has conducted and led criminal justice training programs for law enforcement, prosecutors, and judges in other countries and regions, including Azerbaijan, Namibia, Zimbabwe, Canada, China, and Taiwan. George Pence, from Department of Justice, Counterterrorism Legal Advisor to Sri Lanka, and the Maldives will be our final speaker for the evening. Mr. Pence is a graduate of Princeton University and the University of Virginia Law School. Since 2016, he has served as an Assistant United States Attorney in Los Angeles, California, where he works with law enforcement to investigate and prosecute terrorists and persons engaged in espionage and non-traditional information collection. He is the lead prosecutor in case brought in Los Angeles against Sri Lankan nationals who in 2019 conspired with suicide attackers who detonated improvised explosive devices at churches and hotels in Sri Lanka. We are indeed privileged to have such an esteemed panel as the speakers for this lecture. Let me now invite our first speaker, Al-Ustaz Hussein Shamim, to share his valuable insights on the Maldives judicial system.
Advarante behora befrum. Assalamu alaikum warahmatullahi wabarakatuh. Algondu mi tibefrum isna devvafiya divehi bahun kuriya gendanan mi arun befruna dannawadin. Arun wahakage bodu. Arun wahakage bodu ba divehin gendeveto maseke kurana miyaduge mi lecture session ta intizam koddevi kamattaka ba council ge executive committee yasha adi ba council ga maseke kurava huriha beffunna war ikhlaser kamayko shukur dannawan algon ummid kurani mi program ki wakilunna adi khasako ganun kiyawa vidalwa beffununna war ginaguna mawlumatta libigen daane program ka waane kama adi miya ekko mi taaraf kurave mooting competition na kiwes algon menge masekken noda kiyawa kudinge femmaro ehen darajeka gengos dene kamekkama ada miyaduge lecture ga algon kommeswaraka wahaka dakkadam beenum vi rajyege criminal justice system taraggi wegen gotuge mi fahuge reform ta gotuge wahaka kommeswaraka dandawadan ei mi context nuata mi tarehi hagigetta kommeswaraka fahum wima miwagutu mi kandattan hinga goi ingi wadannawana kaman algonda lafa kuraveti ege bay wahakta dannawadan alun hitangeri mi fursatuge beenum kurana me emme furatama mi criminal justice ke reform ge wahakaye nuata muli judiciary ge reform judicial system ge reform ge wahake dekevuni nuwe june ga raisul jumhuriya eruge raisul jumhuriya asal Muhammad Abdul Gayyum devvi speech ekga mikan kamuge tafsil tahoge wahaka dekkevi e siyasi gotunna adi judiciary islah kurman elidana fiyortaka behe gotun emanik fan dehas 4 wana har june maho wahaka dekkevi ege kurin dehas 3 wana haru iwan nasimge hadisa mi jaluga badijehumuge hadisa hinga diyei den hiafaho dehas 4 wana haruga polissa MNDF wakivi tieteren bay befun engodan fan etidane kuriga sahogiya korawani ves sifang me sifang fuduhunge idara ki sifange terega onna unit e unitum tahogiya korawani ves e unitum mihum bandu kurani ves e huriha fuduhunge huriha masakkate korawani e unitum ehem wima barak fahaka jehendem ves fuduhunge bay kantatta bay kahala practice ta huri warak boda military wattaraka sifanna warak gule gotakan huri adi civil kamaka fuduhunge masekke badalwegen diyei mi dehas 4 wana haruge october mahuge terega criminal justice ge reform agenda dehas 1 wana haru eruge raisul jumhuriya eruge bandarana dr hasan saeeduge duwaswaru heddevi e reform agenda ga maganu nuktayakan oti penal code genna islahata genomge wahakaya criminal justice criminal procedure code ge wahaka kandima kori gotun criminal procedure code eru draft kori code fast kurave goten novi eru draft kori penal code algon menna fast kurevun ehennama se penal code ekko tayyar kurevun e penal code tamfiz kuran tayyar kurevun jinay ijratu gaawna noon miye tolme mi practice kuramun daniki amal kuramun daniki ehem wima bay faharu ega hori wahakataka mi hori wahakataka dima nuwe gossa hunnan den gaawna asasiya genewun islahatu hoge wahaka කොම්මස්වරක මෙන්ෂන් කොල්ලාෆ කුරියද්දානි ප්‍රොසිකියුටර් ජෙනරල්ගේ ಭಾರತಹೋಗೆ ತೆರೆಗ ವರ ತಫಾತು ಆದ್ಯ ಖಿಲಾಫ್ ವಾಹಕತಕ್ಕೆ ಗಾಣ ಅಸಾಸಿಗೆ ಬಹುರಿ ಎಕ್ಕಮಕ ಪ್ರೊಸಿಕ್ಯೂಟರ್ ಜನರಲ್ಗೆ ಭಾರತ ಬಯಾಂಕುರ ಮಾದ್ದಾಗೆ ಬೋವೆ ಜಿನಾಯಿ ದವ್ವಾಯೆ ಕುರುಮುಗೆ ಹುರಿಹಾ ಬಾರೆ ಜಿನಾಯಿ ದವ್ವಾಯೆ ಮಿಹೆಗೆ ಮಚ್ಚ ಕುರುಮುಗೆ ಹುರಿಹಾ ಬಾರೆಂ ಒಂಡನಿ ಪ್ರೊಸಿಕ್ಯೂಟರ್ ಜನರಲ್ ಎಯಿ ದಿಸ್ ತೇವಿಸನ ಮಾದ್ದಾಗೆ ನೂನುಗ ಎ ಮಾದ್ದಾಗ ಮಿಯೊಂಡನಿ ಜಿನಾಯಿ ಕುಶೆ ಕೊಫ್ಫಿ ಕಮುಗೆ ತುಹುಮತ್ ಕುರವಿಜ್ಜೆ ಕೊಮ್ಮೆ ಮಿಹೆಗೆ ಮಚ್ಚ ದಿವಿ ರಾಜ್ಯ ಕೊಮ್ಮೆ ಕೋಟೆಗ್ಗಾಮೆ ದವ್ವಾ ಅಫುಲುಮುಗೆ ಬಾರು ಪ್ರೊಸಿಕ್ಯೂಟರ್ ಜನರಲ್ ಲಿಬಿಗೆ ವಾ ಕಮ එහෙන් ඔයෆා එමාද්දාගේ කාෆුග ඔන්නනී ರೈತಂಗೆ ಮಜ್ಲಿಹಂ ಫಾಸ್ಕುರ ಗಾನೂನುನ್ ಜಿನಾಯಿ ದವ್ವಾಯ ಕುರುಮುಗ ಬಾರು ದಿಫಾವಾ ಎವ್ವೆಸ್ ಫರಾತಕುಂ ಹಿಂಗಂ ಫಶಾಫಾವಾ ಜಿನಾಯಿ ದವ್ವಾಯ ಕುರಿಯ ಗೆಂದಿಯುಮ ಹವಾಲುವುಮ ಮಿಫದ ದವ್ವಾತ ಮುರಾಜಾಕೊಂ ಅಮುರಾ ಗೆನ್ನಂ ಫೆನಿಜ್ಜೆ ಕೊಮ್ಮೆ ದವ್ವಾಯ ಕೋಟುಂ ಹುಕುಮೆಂ ಯುಮ ಕುರಿಂ ಅಮುರಾ ಗೆನೋಮುಗೆ ಬಾರುವೆಸ್ ತೀಜಿಯಂಗೆ ಬೋವೆ ಎಮಾದ್ದಾಗೆ ನೂನುಗ ಹಮೇಕಣಿ ದವ್ವಾ ಕುರಾಣಿ ತೀಜಿ ಕಮಂ ಒಯಫಾ ಕಾಫುಗ ಅದು එහෙම් මිහක දවවා කුරා වාහක එවස් ගෙනසේ බොයි එයි කිහිනවී කමෙත්තෝ දැන් ඒගේ තාරිෆ් අලුගොනවර මා බඩ සදහමත් මොයිස එංගඩන්නවාන එන්නමස් අලුගොන එං ෆෙත්තනුග එකන් දිමාවේ ගොතකී ඒරු එදුවස්වර ෆුදුහම් බේනුම් ෆුළුවි පොලිස් කෝඩ් කියාෆ අදි පොලිස් ප්‍රොසිකියුෂන් කියාෆ වකි ප්‍රොසිකියුෂන් යුනිට් හද්දවෑගෙන් එබේෆුළුන් ගබූල් කරවවා කුදි කුදි මස්සතහක දවවා කුරානි ෆුදුහම් කම හද්දව එමසෙක්කේ කොම්මස්වරක කුරිය දිය එකන් ಹುಟ್ಟುಮಟ್ಟಕ ಗಾನ ಅಸಾಸಿಯ ಗೆನವನು ಇಸ್ಲಾಹೆ ನುವತ ಲಿಯವನು ಮಾದ್ದಾಯಂ ಎ ಮಾದ್ದಾಯಕಿ ದೆಂವೆಸ್ ಪಿಜಿಗೆ ಭಾರತ ಹೋಗೆ ತೆರೆಗೆ ಬೋವೆ ಜಿನಾಯ ತಹಗಿಗೆ ಕುರಂ ಫೆನಿಜ್ಜಕಮ ಫೆನ್ನ ಕಂಕಮುಗ ಜಿನಾಯ ತಹಗಿಗೆ ಕುರಂ ಎಂಗುಮುಗೆ ಬಾರ್ ಮಿಯಸ್ ಆಮುಗತೆಗ್ಗ ದುನಿಯಗೆ ಹೆಂಗಂ ತಹಗ ಪ್ರೊಸಿಕ್ಯೂಟರ್ ಜನರಲ್ ಉನ್ನ ಒಣ್ಣ ಬಾರ ನೂಂ ಅಳಗೊಂಡ್ಮೆಂಗೆ ರಾಜ್ಯಗ ಮಿಯ ಗೊತನ್ ನಿಜಾಮ್ ಒಣ್ಣ ಗಂ ತಹಗ ಎನ್ನಮೆಸ್ ಮಿವಾಹಕವೆಸ್ ಲಿಯಂಜೆಹುನಿ ದಿಮಾವೆ ಹಾದಿಸಾಯಕ ಗುಳಿಗೆಂ ದಶೆಗ್ಗ ಹಿಂಗಾದಿಯ ಕಮೆಗ್ಗ ದೆಬෑ මිහකො තලාෆොලෑගති එක ළඟල බෙලියරුග මිවාගොතකී ෆුදුස්සොෆීහ මස්සල හුෂාලෑගෙන් ෆුදුස්සොෆීහ මස්සල බලානුදීගෙන් දෙබෑ මිහුන් රුලියස්ගෙන් තලාෆොලෑගති දෙන් එකම් බෙලියරුග මිවාගොතකී එරශුග මි පොලිස් ස්ටේෂන්ග හුන්නවා බේෆලෑකී එතරුන් එං ආයිලෑගේ මිහ එහෙම් වීමක ඒ ආයිලාගේ මස්සලය නුවේ බෙලේ මිගොත දිමාවෙගෙන් එකම් බලා දෙන මිහකු නුවගෙන් ඒකම් බෙලේන ගොතෙක් ගානසාසීක ලියම් වෙගෙන් මිවාහක ගානසාසීක ලියවිගෙන් දියයි දෙන් අදි පීජික ಭಾರತಹೋಗೆ එම්මෙ ෆහත මියොන්නනි ගානසාසීගේ එම්මෙහා හමතක ගානුනායි එම්මෙහා ෆර්දුන්ගේ හග්ගුතක මිනිවංකන් නෙගෙහෙට්ටු මිවස් වර ජුම්ලකෝ වර බොඩකෝ මේ වර ෆුලාකො ලියෆොන්න මාද්දාය අනෙක මි මාද්දා ඔන්න ගොතුම් ප්‍රොසිකියුටර් ජෙනරල් බේනුමිය නරදමා සලම්වි ෆාහනා හොලිව සලම්වි ෆෙම්බස්ලා දෙම් මිදන්නේ අසාසි හක්ගුත රක්කා තෙර කුරුමකි පීජේක සිම්මාය වෙජ්ජී යහම හුරියාකමස් කුරම්වි එහෙන්නම සවුන්මෙන් එමාද්දා මේ මානකුරණී එගොතක නුනේ ජිනායත්ලුග නිසාමා ගුලේ ජිනායත්ලුග නිසාමා දිමාලන් අන්න කංකමුග ඒ මාද්දා බේනුම් කොග්ගෙන් ෆියවලත එලිදානකම එහෙම ගාන අසාසි ඩ්‍රාෆ්ට් කරේ ෆොයි ගොතුම් තෆාතු ආදය හිලාෆ් ಭಾರತකෙන් ආදය හිලාෆ් කන්තත්තක එබහුරි ඒග තාරිහි හගීගත්තක එබහුරි දැන් තිබෙෆුන්න ෆාහ කරවෙන ප්‍රොසිකියුටර් ජෙනරල්ගේ වාහක ගාන අසාසීක ඔන්නානීවස් මිනිවම් මොස්සතහගේ වාහක ඔන්න තනුගේ එම්ම ෆහතුක එකම්ස් දිමායි ගොතෙක්කම අලුගොන එන් ෆොති ෆර්තම ප්‍රොසිකියුටර් ජෙනරල්ගේ වකි මුස්තගිල් මීහෙන් ගොත ලාක නූම් ෆර්තම ඩ්‍රාෆ්ට් කරේ තයාර කරේගෙන් දියයිකි එහෙන්නමස් එදුවස්වර හිඟාදිය හාදිසාය ඔගස්ට් 12 හාදිසාය ගුලිගෙන් ರೈತಂಗ ಮಜ್ಲಿಹೋಗೆ ಖಾಸ ಮಜ್ಲಿಹೋಗೆ ಬೈ ಮೆಂಬರುನ್ನ ಏರುಗೆ ಬಂಡಾರನ ದವಾ ಕುರವಿ ದವಾಕೊಂ ಎಮಿಹುನ್ ಜಲಲ್ಲ ನಿಕಂತತ್ತಕೆ ಹಿಂಗಾದಿಯಾಮ ಏಕಮುನ್ ರಕ್ಕಾ ತಿರುಮಟ್ಟಕ ಏಕಮುನ್ ಮಿಂಜುಮಟ್ಟಕ ಮಿನಿಮಮ್ ಪ್ರೊಸಿಕ್ಯೂಟರ್ ಜನರಲ್ ಗೆ ವಾಹಕ ಗಾನ ಅಸಾಸಿಗೆ ಲಿಯುನಿ ಎಹಂ ವೀಮ ಅನೆ ಮಿನಿಮಮ್ ಮೊಸ್ಸಾತಹೋಗೆ ತೆರೆಯಿಂ ಎಮ್ಮೆ ಗಿನ ಭಾರತಕ್ಕೆ ದೀಫುರೆ ಮೊಸಸಾಗೆ ವಾಹಕ ಗಾನ ಅಸಾಸಿಗೆ ಗೆನೆ ಫೋತಿ ಮಿನಿಮಮ್ ಮೊಸ್ಸಾತಹೋಗೆ ವಾಹಕ ಎತ್ತನುಗೆ ಎಮ್ಮೆ ಫಹತುಗ දැන් ෆුරතම ඩ්‍රාෆ්ට් එක එමෙ ෆුරතම ඡාප් කරවුණු මේ ගාන අසාසීක ප්‍රොසිකියුටර් ජෙනරල්ගේ වාහක ඔය මාද්දාක අරිමති සුරුහිය වෙස් නොන්නන් ඒ එහා වෙස් ෆහුම් ඉතුරු කරවුණු මාද්දායි ඒ මාද්දායකි මිදන්න අරිමති සුරුහිය මිදන්නවනි ඒ ලියවුන් එරුගස් අරිමති සුරුහිය වෙස් ජෙහිෆනෙන් හඳාන්නත ජෙහිෆනෙති ඒ ෆොත්ත ඡාප් කරවේගෙන් දියයි දැන් ගාන අසාසීය එක්ක බය බදල්ත හොගේ තෙරේග ප්‍රොසිකියුටර් ජෙනරල් ඔෆීහෙන් උෆෙදිගෙන් දිය ඒ ඔෆීස් උෆෙදුනී නුවත සහමත් මොයිස් හුවා කුරෙව්වී සෙප්ටෙම්බර් 4 2008 බුරස්වේ දුවහෙ අරුන් හඳම්වා ගොතුම් බුරස්වේ දුවහෙග හුවා කුරෙව්වී දැන් අයි වීකෙන්ඩ් ඒ වීකෙන්ඩ්ග මසක්කත නුකුරවේ 7 සෙප්ටෙම්බර්ග අලුගොන්ඩ ඔෆීස් හුළුවී අලුගොන්ඩ මොයිස්සා දෙමිහුන් මේසෙක්ගේ පහතුග තිබින් අනේ ඒතුරු කුරාණ කමෙන්ට්නේ මොස්සෆුන්ඩෙන්නේ එහෙම්වීම හතෙන් එදුවස් දිමාවී කන්දිමා කොරි ගොතුන් රම්දෝන් මහගේ ෆුරතම දුවහක රයිසෆිහුන් ගුළුවා විදාළුවී වසීරුන් ෆෙම්වරුගේ මේස කොලකා වසීරුන් ෆෙම්වරුගේ මේ ගොඩිකොලේ එතනක හුන්නානකම එහෙම්ම අලගොන්ඩු ඉනි වසීරුන් ෆෙම්වරුගේ නූන් ගොඩිකොලුග මොයිසින්නේ වසීරුන් ෆෙම්වරු ගොඩිකොලු කල්මෙන් දෙමිහුන් තිබි ඔෆිස් හුළුවෑගෙන් එදෝ කමෙන්නේ නෙන් ගෑගනක හෆ්තෑන් හාදුවස් ෆහුන් ප්‍රොසිකියුටර් ජෙනරල් ඔෆීහ මුවස්සෆුන් ඒරු ඒජි ඔෆීහක මුවස්සෆුන් බදල් කුරෙව්වි ඒරු බදල් කුරෙව්වි දිහවරකම් මුවස්සෆුන් අදිවස් තීජි ඔෆීහගේ බ උළුවා එබෙෆුන්ගේ මසක්කතුගේ හිද්මත මිහාර තේරහරු එවි දා දිහක දුව අලගොන් මෙන්න ෆුරතම වාරුතවි ඒජි ඔෆීහුන් 11ක 30 හමස්සල වාරුතවගෙන් අලගොන් මෙන්ගේ ඒරුගේ ටර්න් අරවුන්ඩ් කී සතේක සතාර දුවස් ෆුදුහ මස්සලේ පීජි ඔෆීහ ෆොනුවාතා සතේක සතාර දුවහුගේ තෙරේග අලගොන් මෙන්න දවවා කුරන් කෝට ෆොනුවෙනි අලගොන් මෙන් අමාසකවි ඒ අදදු ඒ මුද්දතු 21 දුවහ තිරිකුරුම් වකි මුද්දතෙගේ තෙරේග වකි දුවහෙගේ තෙරේග මියදු ඒ ටර්න් අරවුන්ඩ් ගඩියකී හදුවස් අලගොන් මෙන්ගේ අමාසකී මිහාරු ඒ මුද්දත 4 දුවහ කුරුකුරු එහෙම මී ෆායතේ තේරහර දුවහගේ තෙරේග අලගොන් මෙන්න ආදේෆ හොරි දැන් ඒරු ෆුරතම අලුන්මගේ පීජි ඔෆීහක තිබ්බෙවි සතාර වකීලුම් මියදු මසේ කරවවා සතේක වකීලුම් දැන් ගානුන් තකම් වෙස් බදලතන් ඈසි අධි අලුන්මන් කුරා මසෙක්ක වෙස් තෆාතුවේ ඉතුරු වෙගෙන් හිඟජ්ජ දැන් අලුන් දන්නවාලම් බේනුම් වී බයෙක් කන්තත්තන් අලුන්මගේ ජිනා ඉජරාතුගේ ගානුන අවමුගේ කුරීග වෙස් බයෙක් කහල ඉජරාත්ත අලගොන් මෙන්න ලිබිෆයි බහුට්ටේ කෝටුගේ බයි නිම්මුන් තකුන් මිසාලක තිබෙෆුන් එංගොඩන්නවානේ ෆුදුහුන් මීහක හයියර කොග්ගෙන් එමිහා බන්දුන් දූකොල්ලි නුවත එමිහා බන්දුක බහට්ටන් කෝටුන් නිම්මවෑෆීයා ඒ මස්සද මි ඉස්තිවනාෆ දා හිසාබකුන්නේ ෆුදුහුන්නක ඉස්තිවනාෆක නුවෙ දෙවේ ෆුදුහුන්නකන් හාසිර නුවෙ මේකි ගානුනුක ලියෆයි වාහකේ නුන් මිවාහක අයි දෙහස් දිහවනාහරුගේ නවාර නම්බර් ගසියාගේ සුප්‍රීම් කෝටුගේ එයි ගාසිම් ඉබ්‍රාහිම් හයියර කොග්ගෙන් ගෙන්දිය මස්සලේග්ග අලුගොන් කන්දිමා කොරි ගොතුන් එමස්සලයාගේ සුප්‍රීම් කෝර්ට දියයි අලුගොන්ඩ ඒජි ඔෆීහ වඩන්නවී ඒරු ඩෙපියුටි ඇටර්නි ජෙනරල් ඉබ්‍රාහිම් රිෆත් මිහාර් බණ්ඩාර නැබ් අලුගොන් මෙන් දෙමිහුන් කෝටක් දියයි අලුගොන් මෙන් දියයි ඒරුගේ ෆන්ඩියාර් අබ්දුල් සේද් විදාළුවගෙන් අලුගොන් දෙමිහුන් කාරි අන්නාරේ පුන්නේ ගමන් දියයි අනේ අලුගොන් මෙන් වහි කම කුරාකව්වෙස් විදාළුවේ ෆෙන්නේ දැන් ඒජි ඔෆීහුන් ඒරු ෆුදුහුන් තම්සීල් කරවි එමස්සලාගේ හුකුම් කරවවම විදාළුවී ඒජි ඔෆීහුක නූනේ මිමස්සලාගේ තම්සීල් කරවවානේ පීජි ඔෆීහුන්නේ තම්සීල් කරන් එහිසාබුන් එපීල්ගේ හුරිහාකම පීජි ඔෆී හවාලුවෙන් දී මේකේ ගානුනේක ලියෆය වාහකයන් නූන් ගවෑදේක ලියෆය වාහකයන් නූන් අලගොන් මෙන් දෙන් ඒගේ ෆහුන් එකන් කුරාන උසූල් තක එකන් කුරාන ගොත්තක දස්කොග්ගෙන් එමසෙක්ක ඒකට කුරවේතෝ බෙලි දෙවොන් හද හඳන්න තුම කුරින් එව්වාහක දන්නවාලම් බේනුම් වී ಅವನು ಕುರಿನ್ ದೆನ್ನವಿ ಹೆಂಗೆ ಗಾನು ಅಸಾಸಿಗೆ ಎಮ್ಮೆ ಹಮತಕ ಗಾನೂನ ಎಮ್ಮೆ ಫರ್ದುಂಗೆ ಹಗ್ಗುತಕ ಮಿನಿವಂಕನ್ ರಕ್ಕಾ ತೆರಿ ಕುರುಮುಗೆ ವಾಹಕ ಗಾನು ಅಸಾಸಿಗೆ ಓವೆ ಅಳಗೊಂಡು ಮೆಂಗೆ ಎಫ್ಫಾರಕು ಎ ಮಾದ್ದ ಬೇಣು ಕುರಿ ಎ ಮಾದ್ದ ಅವಳು ಮೆಂ ಬೇಣು ಕುರಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ತಳದಂಡಿ ಅತ್ಲಿಕಮ ನೋತ ಹವಾದ ನುಕರಿಕಮ ತುಹುಮತ್ ಕುರವಣು ಮಸ್ಸಲೆಗ್ಗ ಎ ತಳದಂಡಿ ಹೋದ ದಿನಮಟ್ಟಕ ಪಿಜಿ ಒಫಿ ಹುಂ ಸಿವಿಲ್ ಮಸ್ಸಲೆ ಗೊತ್ತು ಮದನಿ ಮಸ್ಸಲೆ ಸಿವಿಲ್ ಕೋರ್ಟಂ ಹುಷಾಳಾಗೆನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ತಳದನಿ ಹೋದಮುಗೆ ಮಸ್ಸಲೆ ಅಳುಗೊಂಡೆ ಮಸ್ಸಲೆ ಕೋರ್ಟ್ ದಿಯೈ ಎ ಮಸ್ಸದಾಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ತಳದನಿ ಹೋದ ಏರುಗೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹವಾಲ್ ಕುರೇಫ್ ವಾಣೆ ಹೆಮೆ ಎಮಾದ್ದ ಅಣ್ಣು ಬೇಣುಂ ಕುರಿ ಎಮ್ಮೆ ಹಾಲತೆಗ್ಗ ದೆನ್ ಮಿಹಾರ ಎಬೋಯಿನ್ ಏಕಹಾಲ ಹಾಲತಕಂ ಆಸ್ಕಿಂಗ್ ಗವರ್ನಮೆಂಟ್ನ ಮಿ ಏಕಹಾಲ ಇಶಾರಾತ್ ಎವೆಫ ಏಕಮುಗೆ ಮಾಲೂಮಾತ್ ಇರಾದ್ ಕುರವಿಯಾ ಕುರಿಯಂ ಐ ಹಫ್ತಾ ದೆ ಹಫ್ತಾ ಇನ್ ದೋಸ್ತೆ ತಿಬೆಫೊನ್ನ ಲಿವ್ವಡ ಅನ್ನವಾಣೆ එන්නමස් එමාද්දා කොම්මස් වරක බේනුම් කුරේෆ එෆ්හාර බේනුම් කුරේෆ එබොයි ආමුක බේනුම් කුරා මාද්දා එන්නුම් ඒ මාද්දා කි ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಬೈ ನಿಮ್ಮಂತ ಹೋಗಿ ವಾಹಕವಣೆಯರು ದಂಡವಾದಿ 4 ನಂಬರ್ ಗಜಿಯಾಗ ನಿಮ್ಮಾಫೆನ್ ನಿಮ್ಮಮಕ ಗುಳಿಗೆಂ ಅಳಗೊಂಡ್ಮೆಂ ಎಪೀಲ್ ಕುರುಮ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನೋತ ಹೈಕೋರ್ಟ್ ಪಿಜಿ ಒಫಿಯಗ ಫರಾತುಂ ದಾಂಜೆಹೆನ್ ದೆನ್ ಹಮ ಎಬಾವತಗೆ ಮಸಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಿಮ್ಮಾಫ ಒಣ್ಣಾಣೆ ಓನಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಪಿಜಿ ಒಫಿಯ ದವಾ ಕೊರಿ ಮಸಲೆಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ವಿದಾಳೆ ಫೊಂಡನಿ ಪಿಜಿ ಒಫಿಯಗ ನಿಮ್ಮೆವಮಕಿ ಶಿಬುಹೆ ಕದೋಯಿ ನಿಮ್ಮೆವಮಕೆ ಕ್ವಾಸಿ ಜುಡಿಷಿಯಲ್ ನಿಮ್ಮೆವಮಕೆ ನಿಮ್ಮಮಕಿ ಅಣೆಂಗೆಂ ಏಕಮಕ ಸುವಾಲು ಫೆದ್ದೇನ ನಿಮ್ಮುಮೆ ನೂಂಕಮ ಮಿವೆಸ್ ಗಾನುನೆ ಗಲಿಯಫ ವಾಹಕೆ ನೂಂ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹುಕುಮಕುಂ ಅಳಗೊಂಡ್ಮೆನ್ನ ಮಿ ಕಂಡಾಳುವಾ ಫೋಯ್ ಒಯ್ ವಾಹಕೆ ಎಹಮ ಜಿನಾಯಿ ಇಜ್ರಾತ್ ಬೈಕ್ ಕಂತ ತರ್ತೀಬ್ವೆಗೆಂ ಆಸ ಹುರಿ ನುವತ ಉಫೆದಿಗೆಂ ಆಸ ಹುರಿ ಮಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಬೈ ರೂಲಿಂಗ್ ತಕುಂ ಬೈ ಪ್ರಾಕ್ಟೀಸ್ ತಕುಂ ಎಹಮ ಏಕಹಾಲ ಬೈಕ್ ಕಂಕಮ ಗುಳಿಗೆಂ ಅಳಮೆಂ ಪ್ರಾಕ್ಟೀಸ್ ಕುರಾ ಕಂತತ್ತಕೆ ಏಬ ಹುರಿ දැන් PGFගේ මසෙක්කේ උපෙදිගෙන් ඇයරුග මිදන්නවාහෙන් ඒරු ජිනා ඉජරාතොය ගානුන නොවේ ඒරු බය මස්සතහුග රයිසොෆීහුන් එ මස්සලයක දවවා කුරාණන්තෝ නුකුරාණන්තෝ එකමුගේ ලෆයෙන් හෝදන් ජෙහෙ මස්සතකෙන් හුරේ එකන් නිමිගෙන් දියයි මේ ඒජි ඔෆීහුගේ සමානුගේ හෙන්නමස් එයි ඒරු පුරමුන්දිය කම ඒරු ප්‍රැක්ටිස් කරමුන්දිය කන්දත්තකේ බයකාල මස්සතහුග මිසාලක කොරප්ෂන්ගේ මස්සතකුග දවවා කුරුමුගේ කුරින් රයිසොෆීහුගේ හුද්දෙන් හෝදන් ජෙහෙ මරුගේ මස්සතහුගේ දවවා කුරුමුගේ කුරින් රයිසොෆීහුගේ හුද්දේ හෝදන් ජෙහෙ ගොත ඒරුවස් ඔවේ එහෙම එයි අලුන්මෙන් ඒරු ප්‍රැක්ටිස් කරමුන් ආ ගොත කි මිහාරු හම එක්කොන් ඉන්ඩිපෙන්ඩන්ට් කො මේ මසෙක්කේ කුරවේ ගොත ඈස ඔතස් වෙස් දැන් අලුන්මෙන්න මේ මසෙක්කතුගේ තෆාතු ගොන්ජොන්තකෙන් එබ දිමාවේ අද ખાસක ප්‍රොසිකියුටරුන්ගේ මසෙක්කතුගේ විස්නාලංජේ කන්තත්තකෙන් හොරේ අලුන්මෙන්න ඒකමකී මා බොඩුකමක නුවියස් වෙස් එකමකී හයිගතුක මීහුන්නම් වර බොඩුවා කන්තත්තන් හොරේ අලුගොන දෙහස් දිහවන ආහාර දෙහස් නුවේ දෙහස් දිහෙන් හිසාබුක දිමාවි කමකී මේ රෂකුන් ගුළුවා විදාළුවි එරෂුග මීහකු කුකුලේ හිෆා වගන්නගන් උලේ මස්සලේ වර බොඩ ගෝස් වෙගන්නේ මේ උලෙනි දැන් එකම් බෙලියුරුක මිවාගතකී එන් ආයිලායගේ මීහකු අනෙන් ආයිලායගේ ගේග ඉන් කුකුලේ වගන්නගන් ඒ කුකුල් කාලි දැන් ඒ මස්සල ෆුදුහන් තහගී කරවෑගෙන් PGF මේ ඒ මස්සලගේ මස්ලහත ගෝස්වි රටතරේගේ මස්ලහත ගෝස්වේගෙන් මේ කුකුලගේ මස්සල වර බොඩ ගෝස්වේ මේ මිකම කොම්මේකස් ෆුදුහන් තහගී කරවෑගෙන් PGF හිය මස්සල ඇසි අරුන්මගේ ප්‍රොසිකියුටර කුකුලගේ මස්සලේ කී කිහා වරෙගේ කමෙක්කන් එංගොඩ අනුගන්නවාති එබෙෆ්ලා ඉන්නවි එමති ඉෂින්නවයි මෙදෙන්නේ ඒකම ෆියවල නාළුවා ඉන්නවි එකමුගේ බොඩුකන් එංගොඩ අනුගන්නවාති දැන් අරුන්මෙන් බෙලියුරුගම තෙදේ ඒ මස්සලේ බොයි PGF හිය ලිබිෆා අරුන්මෙන් ඒ මස්සලේක ෆියවලලා එක නිම්මිමා ඒ ගෑනක මහෙන් හාදුවස් පහුන් රෂුගේ කතිය කුළුවා විදාළුවේ මිහාර වර රංගලේ මේ කුකුල මස්සල හල්දු වෙජ්ජේ අරුන් දන්නව මියුලේ වාහකේ කී අරුන්මෙන් හැම එකනි මාදේක නූනේ ජිනාය මස්සතන් හිඟණීයේ රඩ්ඩෂුග දිමාවා කන්තත්තක දිමාවා මස්සතක ಕಂಕಮಕಿ ವರ ತಫಾತು ಕಂಕಂ ಅಳುಮೆಣ್ಣಂಗೆ ಹುರಿಹಾಕಮೆಂ ಇಗ್ಗೆ ಏ ಹುರಿಹಾಕಮೆಂ ಎಂಗಿಗೆಂ ಅಸ್ಲು ಮಿ ಜಿನಾಯ ಅದ್ಲುಗೆ ನಿಜಾಮ್ಗೆ ತೆರೆಗ ಮಸಕ್ಕೆ ಕುರೆವೇಣಿ ದೆಂಗ ಮೈ ಗೊತ್ತಂ ವರ ತಫಾತು ತಜ್ರಿಬಾತಕ್ಕೆ ಕುರೇಫ ಹುರೆ ಮಿಸಾದಕ ಅಳುಮೆಂಗೆ ಬೇಫುಳಕು ದೆಂ ಕುರಿಗೊಂಡ ಗೊತ್ತುಂ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಜನರಲ್ಗೆ ಮಸಕ್ಕೆ ಕುರವ್ವಾಣೆ ರಶುಗ ತಿಬ್ಬವಾ එහෙන් ඔෆිසරුම් වෙස් මිසාදක කතීබුම් වෙස් ඉමාමුම් වෙස් මුදිමුම් වෙස් වඩන්නවාන PGF එක ෆරාතන් දවවා කරවම් එකන් හුට්ටිගෙන් මිදියේ දෙහස් අවවනහරු ඒක පහම් මිජෙහෙනි PGF එහෙන් වකීලකු දතුරු කරවම් ඒ රෂ මේ මසෙක්ක කරවම් නොත දවවා කරවම් දැන් අවුල්මෙන්ගේ බේෆලක වරඩන්නවා ෆිරෂක දැන් වකී රෂ වෙස් දැන් මිතාක දෙන්න විදාන මීල්මි බේනුම දක්කා වාහකේ මීමතලක රෂක ප්‍රොසිකියුටර්ක වඩන්නවි එබේෆලා විදාලවි හුරිහා රෂ එම්මෙන් එවතිබ්බ නුකුමේ රෂ රයිතුන් එවතිබ්බ නුකුමේ මාදෙන් වකීලක වඩන්නවාති ඒ වකීලගේ ඉස්තික්බාලුක මේ වකීල වඩන්නවි එරෂකෙන් එහාතනන් එම්මේ බොඩු මස්සලෑග වකාලත් කරවම මාදෙන් වඩන්නවා බේෆලා වඩන්නවාති රෂ එම්මෙන් නුකුමේ තිබී ඒ චෙක් බොස් මස්සලේ මේ අරුන්මෙන් මාදේක දුවාදකු තින් හතර මස්සල නොත් 20ක මස්සල ප්‍රොසෙස් කරා කමේ චෙක් පොන්ස් මස්සල එක මාදෙන් බේෆලක වඩන්නවාති රෂ රයිතුන් නුකුමේ එබේෆලාගේ ඉස්තික්බාලුක තිබ්බෙවි කමන්දෙන් අදිය සෙබේෆලා අරුන්මෙන්නක මසෙක්කෙන් එබ කුරවවා මිකා තජරිපාතකෙන් අරුන්මෙන්න කුරේෆ හොරි අරුන් දන්නව මුලේ වාහකයේ මි දායරන් නුකම වඩන්නවාරුග හැම එකනි මාදේක නූනේ මසෙක්කෙන් ඔති කියේ මුනි රාජ්‍යයක මුනි රාජ්‍යයේ කන්තත්තන් හිඟාගොයින් එංගිගෙන්නේ අලුන් මෙන්න මේ මසෙක්ක කාමියාබ් කමායක්කෝ අදි මීහුන් හිංගම ජෙහෙ ගොත අලුගොන් මෙන්න කුරවෙන් දැන් කොරියත් දාරුග මේ අලුන් මෙන් ඈ හිසාබකි මිදන්නවහෙන් මේ අලුන් මෙන් මේ අයි මි හිසාබුන් පෙරිගෙන් කොරියත් දාරුග අලුන් හිතුන් මිහාරු තිබේෆුණු මිස්නාවඩන්නවන් ජෙහෙ කමෙන් ඒ බොයි මිහාරකුවේ හයි කෝට සුප්‍රීම් කෝට වඩාන් අලුන් මෙන් ආමුකම් මිබුණා බුගතන්නවා බ්ලෆ් කොෆ්ෆකාය වඩාන් නුගෙන්නවෙන් අලුන් මෙන්න තයාර නුවේ ගොස් හෝම්වර්ක් නහදා ගොස් වාහකයන් නුදෙක්කෙවෙන් කුරී ගවුන් මෙන්න කොම්මෙ ෆද වාහකෙන් වෙස් දක්කා පහම නොස් එංගේ කම හදාෆ නුකුමගෙන් දෙවේ එහෙන්න මෙස් මිහාරු එහෙන නුවානේ එහෙන තිබෙෆුණු විස්නාවඩන්නවන් ජෙහෙ කමෙන් තිබෙෆුණු තයාර වඩන්න වයරුග මේ රංගල තයාර වෙගෙන් වඩන්නවා තිබෙෆුණු කියවා විදාළු වෙගෙන් නුකුන්න වයරුග අදි ප්‍රැක්ටිස් නුකුම වඩන්න වයරුග අලුගොන් මේ උම්මීද කරණී ඒකන්ත ක්‍රිමිනල් කෝට හමගේ සොන්නන් ක්‍රිමිනල් කෝට හමයාග වෙස් දරු කෝට හමයාග වෙස් හම බේනුම් හා වාහකේ දක්කා වඩා නුගෙන්නවේ වර ෆණ්ඩියාරුන්න කංකං ඉගොඩන්නවානේ ෆෙක්ට්ස් ඉගොඩන්නවානේ ගානුන ඉගොඩන්නවානේ එම වර බොඩු චැලෙන්ජ් කුල්ෆුල් මතීග මියොති මිකං කොරියත් දාර කොන හිතන් අරණී අරුණ විස්නාලෙන්ජේ කමකේ කොන් දායරායකුන්තෝ කොරිය වඩන්නවානේ මිසාලක ක්‍රිමිනල් ජස්ටිස් එකී වර බොඩු වර ෆුලා දායරාය අලුගොන චූස් කුරි ක්‍රිමිනල් ජස්ටිස් ගේ දායරයන් කොරියද්දා අලුගොනක නේගේන සිවිල් මස්සතෝ කන්තත්ත වාගොතේ අලුගොනක වගුතෙන් නෙක් සිවිල් මස්සතෝක සුප්‍රීම් කෝට් නිම්මා නිමුන්ත කියා සිවිල් කෝට් නිම්මා නිමුන්ත කියා අද මිහාර යන්නනි සිවිල් ප්‍රොසීජර් කෝඩ් ඒ ෆිසාරි පොඩු ගානෝනේ එම ඒ ගානෝන වෙස් කියාගෙන් දස්කොක්ගේ මිහුරිහා කමක වගුතෙන් නෝන්නානේ ඒ හුරිහා කමකන් ખબීරක නුවවිදානේ මිහාරුස්වර විස්නා වඩන්නම් වී තිබේ ෆ්‍රම් වඩන්නම් බෙන් ෆුල්වා දායරයකි කොබාතු ඒ දායරයකුන් වීහස් බොඩක් මේ සුප්‍රීම් කෝට් ගසියාතම් වෙස් විදාළුවේ ගානුනතකන් අන්න බදලතම් වෙස් විදාළුවේ මිකංකන් කුරවුන් එයි මිහාරුසර තිබෙෆොන්න කුරව විදානකම එකම අලුගොන හිතන් අරණී මිහාරු වෙස් ජිනා එජරාතුගේ ගානුනන් හතරු ඉස්ලාහෙන් ඇසි මේ හයි කෝට්ගේ බයි ගසියාතහුගා මිහාරු වෙස් ගෝස්කෝ එබ නම්බර් ලියුවා අදි තිරීග මිහාර ඒ ෆොහන් හද්දම් ෆෙට්ටේ ගොතකි තිරීග ලියුවනි ගානුනන් හා බදලා කුලිගේ නම්බර බදල් වෙජ්ජා නම්බර බදල්වානේ මිගොත ලියුවා ෆෙස් මිහාර හුකුම්තෝගේ පරිමාණේ කි එවර ෆොලෝ නුකුරවේ අරුන්මන්ගේ බය බේවේ ෆුන්න එහෙම කුරියෙන් වෙත්තනුගෙස් අදි ඉතුරු ලිටරේචර් වෙස් ඉතුරු වෙගෙන් දාන ඉතුරු ගානුන්තම් වෙස් අන්නානේ අදි සුප්‍රීම් කෝට්ගේ නිම්මුන්තම් වෙස් ඉතුරු වෙගෙන් දානේ දායරුගා කොන් දායරයකුන්තෝ කුරියක් දානි එයි තිබේ ෆුන්න මිහාර විස්නාවඩන්නවන් රංගල නුක්තයක්කම ෆෙන්නාති ඒවාහක අලුගොන් දන්නවාල බේනුම්වි එහෙම ජුම්ල ගොතෙක්ගා අලුගොන් මෙන් ක්‍රිමිනල් ජස්ටිස් සිස්ටම් මිදිය 20කන් ආහාර බදල් වෙගෙන් මියයි වර තෆාතු ගොයික් ගොත වර තෆාතු තජරිබාතහක එක්කොන් අදි බයික් කහල ෆසේ හතක එක්කොන් හෙන්නමස් බයික් කහල ගොංජහුන් තකාවස් එක්කො අදි කුරියෙන් වෙත් තනුගවස් එකන් හිඟාණි ඒගොත අලුගොන් හිතුන් අලුන් මෙන්ගේ චැලෙන්ජ් එක වාණි මිමියොයි මස්රහුගේ තෙරෙන් මිසාලක මිහාර අලුන් මෙන් මිදක්කනි ගානුන් හදා වාහක දක්කායරුග බයික් ගානුන් තන් එබර අලුන් මෙන් බේරුන් නුකරවේ ගානුන් මිසාලක ගේන් කුත්ත මනාකුරා ගානුන් දැන් ගානුන් හෙදුමකි වර සියාසිකමකේ මිදන්නවනි කමෙත් දිමාවීමා බේෆුලුන් කීරිත කරවවා ගානුන් හද්දවනි හෙද්දෙම හොන්නනි හුන්නා නෙච්ච මිසාලක ගේන් කුත්ත මනාකුරුමා බෙහෙ ගානුනක ලියුවා ෆේ බෝවේ හානෙන් නුහර වේනේ දැන් හානෙන් නුහර වේනේ එහෙන්නමස් එනගේ මුවක්කිල මුනනි තිමන්නකේ ෆරස් මාතොඩා මීහකේ තිමන්නොති විලිංගිලිග නිදාෆේ බුණීමක එන් කොම් බේනුම කුරානි දැන් අලොන් මෙන් කුරාන බේනුම යකුන්නේ හානෙන් නුහර බයාන දීෆි බයානක මස්සදයා බෙහෙ වාහකේ නුදක්කඤ්ඤකා අලගොන් මෙන්නක එකම කුරවේන කමන්නේ දැන් ෆහොන් හෙද්දේ කානුන්තව එකන් හල්ලකොත් දෙවවා ෆේ බොයි මි චැලෙන්ජස් අබදුස් උන්නානේ.
Good evening. I would like to start by thanking the Bar Council for making possible this opportunity to speak with you. I would also like to thank the PG for the warm welcome he has extended to both Yiting and I since we have been in the Maldives. We have enjoyed our opportunity to work with him, and we look forward to working with him and his outstanding team in the months and years in the future. And I would like to thank you for coming here tonight, late in the evening, to listen to some lawyers talk about their job. We are here as advocates for the rule of law, and we appreciate the interest you have expressed by even attending in that principle. So today, Yi-Ting and I would like to talk about the United States criminal justice system. Now, the United States has multiple, often overlapping criminal justice systems. And this results from the fact that under our Constitution, some powers are vested in the federal government, which is located, or at least headquartered in Washington, D.C. But those powers that are not vested by our Constitution in the federal government are reserved for the states. And there are 50 of them. There are also some territories. And there is the District of Columbia. And each of those states and the district and those territories have their own criminal justice systems. So as a result, we have a federal legal system and many, many state legal systems. Today, I would like to focus on the federal criminal justice system, which is the system that I serve as an assistant United States attorney in Los Angeles, California. Now, I would like to, and Yi-Ting will do this as well, walk you through our criminal justice system as if you were a criminal that had just been arrested. So, the bedrock of our criminal justice system is the United States Constitution. It is a short document, and it often speaks in generalities. But over the last several hundred years, through our court system and through implementing legislation by our Congress, we have come to define many of the terms that are set forth in our Constitution. For instance, our Fourth Amendment guarantees protections against unlawful searches and seizures, often requiring that such searches and seizures only occur after obtaining a search warrant issued and authorized by a judge. We also have our Fifth Amendment guarantees of due process. Now, the term due process doesn't necessarily have a well-established meaning. So often what we do as lawyers, as prosecutors, and as defense attorneys, if there are any here, is litigate that concept and come to a better understanding of what due process means as set forth in our Constitution and how it should be applied and interpreted in civil society. Under our Sixth Amendment, we have guarantees to trials and felony criminal cases at the very least. And in the United States, we have a jury system, which I understand is different than the system that is employed here. But the jury system is guaranteed under our Constitution, which means that in the United States, if you are charged with a felony crime, a cross-section of your peers, teachers in your schools, the person who works at the takeaway shop, may sit in judgment of you and may determine whether or not the government has proved beyond a reasonable doubt whether you have committed a crime. We also have our Eighth Amendment, which guarantees citizens against bail and punishment that is unduly severe. And often we are litigating in the United States the parameters of what constitutes too severe a bail or too severe a punishment. Now, the Constitution provides those broad concepts, but those concepts are given everyday implementation in our United States Code, which is a collection of statutes that governs our criminal procedure, as well as provides the substantive criminal law. We have the federal rules of criminal procedure, which are authored by the courts and implemented by Congress. They provide the framework for which the judicial process will proceed, the deadlines and the guidelines that lawyers will use and avail of as they work their way through the criminal justice system. We have a very lengthy federal rules of evidence that establish very specific rules as to what evidence can be introduced at trials and at court proceedings, and what evidence would not be admissible in a court of law. We also have case law, which is a very important part of our legal system. Over hundreds of years, our courts have made written pronouncements and interpretations as to what the law means, and we often look back at precedent and argue from precedent how the law should be interpreted in the particular case that is before the court. And then, because we have so many courts and so many people, and it is administratively difficult to keep the trains all running on time, courts often have their own local rules, their customs, standing orders, and practices that are acknowledged and kept by the members of the bar that practice before those courts. So, in the federal criminal system, there are a number of ways that a case can begin, but commonly a criminal case will begin with a complaint. Now, criminal complaint is often authored by a federal agent, an FBI agent, a Homeland Security investigations agent, a customs agent, and it will detail the allegations against the defendant. The allegations that, in the agent's view, are sufficient to support a criminal charge. That criminal complaint will be brought in front of a judge, and it will be sworn out under oath. If the judge agrees that that complaint contains probable cause that the defendant has committed the crime charged, then an arrest warrant may issue. After a criminal complaint is issued, an arrest warrant issues, law enforcement is still required to go before a grand jury and obtain an indictment, which is a concept I'll get to in just a minute. Another way of bringing a criminal case is through indictment. Now, we have what's called a grand jury in the United States federal criminal system. It is a group consisting of anywhere between 14 and 20 odd people. They meet in secret, and in those proceedings, federal agents and witnesses are brought, and they are allowed to testify in front of the grand jury. A prosecutor will propose a charge to the grand jury, and then the grand jury will vote upon it. And a minimum number of votes is required by the grand jury members before an indictment issues. Now, much like the petite jury that you might see on the television where you see criminal trials occur, our grand jury actually consists of common, everyday, ordinary citizens as well. They are randomly selected from the population and may come from all walks of life, maybe 20 years old, they may be 65 years old, men, women, people of from all sorts of communities within our population. And they are the ones that will determine whether an indictment will issue. We also have criminal informations, which are used less frequently, but they are often used for less severe offenses, misdemeanor crimes, and as part of negotiations with a defendant, before charges are ever brought, a criminal defendant may agree to forego the indictment process, may agree to forego a criminal complaint, and agree to be charged by information. And an information is simply a document setting forth in short, plain language the crime charged against the defendant. So, once a criminal charge is brought, hopefully the defendant will be arrested. Under our system, the defendant must appear after his arrest within 24 hours. Initial appearance basically means his first appearance in a court of law before a judge. At that initial appearance, the judge will determine whether or not the defendant should be detained. That detention decision is reviewable, but often is a very important part of the criminal process, because it is very rare in the United States for an initial decision to detain a defendant to be overturned or changed during the course of a criminal proceeding. So if you are detained at your initial appearance, it is very likely you will be detained until a jury renders a verdict as to your guilt or innocence. We have also in the United States a preliminary hearing system, which is again not commonly availed of, but is available. In a preliminary hearing system, what that means is after a defendant is charged with a complaint, but before a grand jury weighs in on whether or not to charge the defendant, the government must go before a judge in a adversarial hearing where the defendant is present with his counsel or her counsel, and evidence is presented to establish probable cause that the charge against the defendant should be allowed to go forward. Finally, there is arraignment, which is where the rights of the defendant are advised to him or her, and the case moves forward. Now, you've heard about informations, complaints, indictments. Those are all procedures that are available in our system where the government has the opportunity to investigate a crime and to consider whether or not to bring charges. But not all crime occurs such that the government has a lengthy period of time available to it to investigate. Sometimes crime occurs on the street, and a federal agent or a police officer may become aware of it and must engage in what we call a probable cause arrest, which is an arrest that the agent is empowered to commit, but he must then go seek approval for that arrest from our courts of law. So after a probable cause arrest occurs, a federal agent must go to a judge and usually file a criminal complaint setting forth the facts upon which that agent decided to make the arrest in the first instance. After a probable cause arrest, a defendant is guaranteed the right to appear in front of a court of law and have his charge considered by a judge within 48 hours. Just to review, you have arrests by warrants, which are documents authorized by a judge empowering federal agents to commit arrests. Those arrest warrants can issue after a complaint is filed, after an indictment is filed, and then, of course, arrests can occur on the basis of probable cause on the street. Now, initial appearance is a very important event. It can often be a traumatic one for a defendant because that is where the defendant is brought in front of a judge and required to present himself or herself for that initial determination as to whether he or she should be detained. At that initial appearance, the defendant is notified of the charges against him or her, the penalties that he may face if he is convicted, and is provided also with a summary of the rights that criminal defendants have in our justice system. Well, that had an interesting effect. So, detention. You're right. The court's power to detain you is controlled by the Due Process Clause of our Constitution, which I said is an abstract concept that has been implemented through statute and by rules promulgated and adopted by the courts and Congress. Among the most important rules that is implemented by our courts is the right against excessive bail. Now, you can look through the Constitution of the United States and you will not find precisely what constitutes excessive bail. There is no dollar amount that is described. There is no guarantee of appearance that is described in the Constitution. But that is a principle that all courts must implement when they are deciding whether or not it is appropriate to detain a defendant before the defendant stands trial. And that is a very important concept under our Constitution, because under our Constitution, criminal defendants are presumed to be innocent. until they are actually proven guilty. So the protections that are set forth against excessive bail, the protections of due process, the rights to trial by jury, those all acknowledge that core concept we have under our Constitution that no person is guilty until a jury decides that they are so. Now, as I said, what constitutes excessive bail is not defined in our Constitution with any great degree of particularity. So we have a statute, the Bail Reform Act, which provides more concrete guidance to prosecutors and defense attorneys in determining whether or not a defendant should be detained. Now, there is in our system the presumption of release, which is to say, because everyone is presumed innocent when they are first brought before the court's presumption is that they should be allowed to go free. It is therefore the government's burden to prove to the court's satisfaction why that presumption should not be implemented and why the defendant should be detained pending trial. Now, there are two factors that courts focus on in our system at this initial appearance. They are flight risk and danger to the community. What that means is, can the court guarantee that the defendant will actually show up for trial? Now, at a detention hearing, the government will often argue that the government cannot guarantee that the defendant will appear, that there are no condition or combination of conditions that will ensure that when trial begins, the defendant will be sitting next to his counsel waiting for the jury to render a verdict. Danger to the community is also another factor the courts in our system are empowered to consider. If a defendant is alleged to have engaged in a violent crime, if the defendant has a history of criminal activity, if the defendant has a history of drug abuse or alcohol abuse, or engages in behaviors that may make them a liability within our society, those are factors that a court is able to consider when determining whether or not to detain the defendant. Now, in certain cases, the government doesn't actually have the burden of persuading the court that the defendant should be detained. And that's a very narrow range of cases that involve very serious offenses. Serious drug crimes, serious violent crimes, crimes against children, and terrorism, which is the field that I operate in at my U.S. Attorney's Office. All of those types of cases carry the presumption that the defendant should be detained before trial. Even then, though, because the presumption of innocence is so strong in the United States, most judges will want to hear more information about the defendant before deciding to detain them, because that presumption of innocence is so strong, and because there is that very strong presumption that they should be released before trial. Now, at that detention hearing, the government has the opportunity to weigh in on the court's decision. Defense counsel has the opportunity to weigh in on that decision. And we also have, in the federal system, a branch of our courts called our pretrial office. And the pretrial office provides an independent perspective to the courts. Oftentimes, they will interview the defendant, get their family history, their criminal history, determine whether or not the defendant has ties to the community or whether they have bail resources, and they will be a third voice making a recommendation to the judge. So because this detention determination is so important in the life of a defendant, multiple voices are heard at this initial hearing. Now, preliminary hearing, which I will cover just very, very briefly. Let's say a defendant's arrested under a criminal complaint, which you'll recall is a complaint that's sworn out by an agent in front of a judge. But the grand jury hasn't weighed in on whether or not to actually indict the defendant. Under those circumstances, there may occur in the United States a procedure called a preliminary hearing. Now, at that hearing, the government will be required to show up with witnesses and present to the court its witnesses, and the government must show to the court's satisfaction that there is probable cause that the defendant committed the crime charged. Now, at this hearing, the defendant will have the opportunity to cross-examine the government's witnesses. So often, this procedure can appear like a mini trial that occurs before the actual trial that determines whether or not the defendant is guilty. Because it is a mini trial, and because the government must put on witnesses at this trial, it is often the case that the government decides to indict before the deadline that would require it to make and appear at a preliminary hearing. And as mentioned in the last bullet point, a preliminary hearing is not necessary in our system if an indictment is filed, which is why the government will often work to secure an indictment from the grand jury before preliminary hearing occurs. Now, the indictment is really the fundamental charging document in our criminal justice system. Except in very, very, very rare cases, the indictment is publicly available. Any member of the public can go online, can read the charges against the defendant, and know the bases of the prosecution that is being brought against him or her. After the indictment is filed, there are deadlines that are triggered, requiring that the government proceed with its case against the defendant with all due speed. Now, under our Speedy Trial Act, the government must bring a defendant to trial within 70 days of indictment. Now, often the trial date is continued in the federal legal system, but that usually only happens when the defendant requests it. If the defendant does not request a continuance of his or her trial date, under the law, the government must, in almost all cases, bring a case to trial within 70 days. A not unique, but a very interesting part of our criminal justice system. There is an old joke in the United States that a grand jury will indict a ham sandwich. And having presented in front of many grand juries, I can tell you that is not the case. Grand jurors in the United States are appointed by the court. They meet in secret, and they very often take their jobs very seriously. And the reason they take their jobs very seriously is because they stand as gatekeepers. If the government is not able to persuade a grand jury to authorize a charge against the defendant, that charge is not going forward. So that grand jury stands as a bulwark of protection for a defendant's rights. Now, because the grand jury has such a tremendous responsibility, and because they must deal with very sensitive matters, they meet in secret. And you could understand why that would be the case. If a grand jury chooses not to indict a defendant, there is no sense in having that defendant's name dragged through the mud, which is why the grand jury meets in secret. And only after it has determined to charge a defendant is the work of the grand jury made public. Now, at the end of this presentation, my colleague Yiting and I and the PG will have the opportunity to answer questions from you all that may be specific to our presentation and to the work that we are doing here. But without further ado, I'd like to turn over the presentation to my colleague, Yiting.
Good evening. I'm Yiting Wu. I have been a federal prosecutor 27 years. So do you want to guess how old I am? I think I'm only 29, right? Don't you think? Don't you think? Yeah. So before I was a federal prosecutor, I was a state prosecutor. So you know how George talked about the two different systems? We have the federal system and the state system. So I practiced in both systems. And some of what I'm going to cover next actually is almost identical, regardless of whether you're in the federal system or you're in the state system, for purposes of the criminal justice process, the procedure, okay? Now, I'm going to tell you something. I have an advantage of going last. Do you know why? No one wants to say. Because I got to hear what PG Shamim said. No, my Devehi is not that good. In fact, my Devehi is non-existent. I'm very sad to say. However, he gave us the privilege of telling us in advance what he would say. So I knew generally what he was going to talk about. That was my benefit with respect to PG Shamim. I also have the benefit of course, listening to my colleague, George Pence. Now, we had our slides, we reviewed them together, but I didn't know exactly what he was going to say. He could have told jokes the whole time and just went slide by slide. That's fine. But the benefit to me hearing what they have to say is I can mix it up. I can say anything I want now. I don't have to follow along. And actually, what I want to share with you is a connection to the history, what PG Shamim had told you about how reform, judicial reform started, okay, was kicked off, so to speak, in Maldives. And it reminded me, so the Evan Nassim case, right, is what generated momentum in Maldives for judicial change, for important change, the creation of the Prosecutor General's office. And we have leading cases in the United States that did that for us as well. It reminded me of that. And it reminded me that these cases are at the core of the rule of law and the Constitution and how we apply the rule of law and our Constitution in all of our criminal cases, regardless of whether we are a prosecutor or whether we are a defense lawyer, regardless of what side we're on, so to speak. Now, the PG has had really the benefit, the honor, and the privilege of being on both sides. He has, from the defense side, he has seen it, from the prosecution side, he has gone to both, okay? And that gives him the insight on what it means to serve justice and to be all things that encompass justice. I have a little bit of that. I was for some years, very few years actually, I worked for a commercial law firm, similar to what George did. And because I was the only lawyer that had any background in prosecution, I was directed to represent every client in that commercial law firm that was charged with a crime. So without intending to, I became a criminal defense lawyer. So although it was a very short period of my career, it gave me a glimpse into what it means to represent someone who has been charged with a crime. It gave me the ability to look from the other side. And it gave me a greater appreciation for the Constitution and kind of the bedrock of due process and rule of law in the United States. And what I have learned here in Maldives in the very short time that I've been here, which is 2 months, is that it is also the bedrock of your criminal justice system here. The rule of law and due process is honored. I see it every day in the PG's office, in the Maldives Police Service, in talking with people who are lawyers who don't necessarily practice in criminal courts, in talking with people who intersect with the criminal justice system, including victim advocates, people who work with what we call the marginalized community, the people who don't have the most access to the criminal courts or to the court system at all. There is great momentum and great movement here to improve your system and to build it up. And as we are in the United States, we're constantly reforming. Every year, George and I have to read new laws and amendments. We have to change our practice because our legislature has said, no, we want you to do things a little differently, and we have to make that adjustment. And that is exactly what's happening here in the Maldives as well. Oops, wrong way. Oh, keep going the wrong way. Oh, yes, this is what I want, outline of proceedings. Okay, before I get to the outline of proceedings, so I wanna ask, who can name one important United States Supreme Court landmark case? And you can become my WhatsApp friend. Probably nobody wants to do that, so no one's gonna raise their hand. If I had chocolate or candy, I would give it to you. That was my mistake. I should have brought that tonight. Can anybody name one? I know you're talking, okay. Oh, yes. Very good, woo! Okay, you get to be do you wanna be my WhatsApp friend? Perfect, great, okay. What is Roe v. Wade about? The right to abort, okay. Not a pleasant subject, a difficult subject, and actually, it's a very political subject in the United States. And I'm not gonna go there right now because that's a whole other session. You want me to come back and talk about it? I'm happy to do that, but not tonight, okay? So, thank you. I'm going to mention two Supreme Court cases that were integral to how the United States court system, particularly with respect to the rights of defendants, have affected our criminal procedure code, our case law, and how courts operate in the United States. Those two cases are Gideon versus Wainwright, okay? Gideon versus Wainwright is a case from 1963. I had to look it up real quickly because I couldn't remember it off the top of my head. This case was about a person who was charged with a crime. It was actually a very petty crime. But he was not given the right to a lawyer. He was not given the right to talk to a lawyer before making any critical decisions about what was going to happen in his court case. And this case, this man actually took this case by himself and ultimately ended up getting a lawyer when he got to the Supreme Court. He took his case all the way to the Supreme Court. And the Supreme Court issued the decision in Gideon versus Wainwright that every person charged with a crime has a right to counsel. And if you can't afford counsel, the government, whether it's the federal government or the state government, has to provide counsel for you. That was a sea change in the United States. That was phenomenal, okay? I would say, fortunately I can say I wasn't born then. I was only born like a couple years later, if you really want to know my age. But it really rocked the criminal justice system. It put us in a flurry. People didn't know what to do. It took years to implement that, okay? Now, the other bedrock case that we hear about and think about and apply all the time in our cases is Miranda versus Arizona. Who's heard of Miranda Rights? Do you know what Miranda Rights are? Okay, see, I won't call on you. You're lucky because you're way up there, otherwise you'd have to scream your answer down. Miranda is exactly what George talked about. The right to remain silent, the right to have counsel, the right not to make any statements against yourself, the right to be informed of your charges, okay? All of those rights, this is that case, Miranda versus Arizona. That case was out in 1963, so right next to each other as well, okay? just around the same time, these phenomenal cases came out of the United States courts and changed our whole system of how the police had to operate, of how prosecutors had to make decisions. And many times these prosecutors could not proceed with charging because those rights were not honored, particularly under the rights for Miranda. Now, I bring this up and I say, I got to kind of change things up. And I wanted to give you a glimpse of how judicial reform is shaken up. It's always about a person's life in criminal cases that shakes up judicial reform, just like in Evan Nassim that you experienced here, just like in the Miranda case, in the Gideon case. We have lots of cases that we can refer to. And it does affect the proceedings that occur. Why is it, for example, discovery is the exchange of evidence. The government, the prosecution, has to give evidence to the defense. We have to give them all the evidence. We can't withhold evidence. That is a due process right. That's a constitutional right. And it lies directly as well in all these Supreme Court cases that are very important. One case that we have is Brady versus Maryland. It's in the next slide, okay? In Brady versus Maryland, the Supreme Court said, government, state, prosecution, you have to give over all evidence, even if the evidence may help the defendant. In fact, you have to give them evidence that arguably could help the defense. You might not think it's helpful. That's not your decision. The decision is whether or not counsel for the defendant thinks it could help their client. That's the case of Brady versus Maryland. Pretrial motions are where the parties litigate with each other, okay? So on legal issues and on factual issues, I'm going to just really briefly go over change of plea hearing, but obviously that's when a defendant decides, I'm going to plead guilty and I'm going to make the process more efficient. I'm going to admit that I committed the crime, I did something wrong, and because I made that admission, or a confession, I will get some benefit for taking responsibility as early as possible. A pretrial conference similarly is held here, where the judge and the counsel for the defendant and the prosecution, they come together and they talk about what is the logical steps that we are going to take to prepare for trial. What do we need to do to get ready for trial? That's the purpose of a pretrial conference. Of course, trial is where we submit evidence, okay? And then the judge or the trier of fact or juries in the United States, for the most part, has to make decisions about whether or not somebody is guilty or not guilty. If they're guilty, they have to make a unanimous finding beyond a reasonable doubt. And then we have, obviously, sentencing. And I'll get to that in a moment. So, I've done a lot of talking that is off the slides, right? So I'm going to stick with the slides for a few more minutes. Brady versus Maryland, as I said, Supreme Court case, duty to produce all evidence favorable to the defense. We have a requirement that we have to give within 14 days, or at least start the process of giving all the government's evidence, all the state's evidence to the defense. Very similar system here. I know within a week, I believe, of placing the charge, once the court sets that first hearing for the defendant, the PG's office has to give all of their evidence to the court and to the defendant, okay? That is part of due process that lies within the heart and the principle of the Constitution. Plea of guilty. We have a federal criminal rule that tells us what we have to do to ensure that a defendant's decision to enter a guilty plea is knowing, voluntary, and intelligent. And there's a process. There is what we call a colloquy. There's a set of questions that the judge asks the defendant at the time they plead guilty to ensure that they were fully informed of their right to trial. They're fully informed of their rights, essentially under Miranda, that they can remain silent. that their silence cannot be held against them at trial, that they can call witnesses in their defense, and that they're represented by counsel. And once the defendant then says, I know those rights, I've consulted with my lawyer, and I voluntarily plead guilty, the court can accept that guilty plea. We also have to be able to show that that plea was not, there wasn't a bribe involved. Nobody threatened the defendant. No one, he or she did not make that decision under coercion or duress, okay? And the defendant has to agree to a set of facts that support the crime that is being charged. So, with respect to sentencing, this is where we are guided, again, by the Constitution, under, for example, the Eighth Amendment, to be free from cruel and unusual punishment. So the sanction, the sentence that's imposed on the defendant cannot violate the Eighth Amendment, okay? It has to be a legal sentence. It has to be below the maximum sentence of imprisonment that is set by statute. So every crime, just like here in Maldives, every crime has a maximum sentence. So as long as that crime is below that maximum sentence, usually it's legal. There are some caveats there, which I'm not going to get into, but usually it is a legal sentence. What we are guided by as federal prosecutors is a statute that tells us that we have to, or that the judge has to impose a sentence that is sufficient but not greater than necessary to reflect the nature and circumstance of the offense, to deter the defendant from committing future crimes, from ensuring public safety, to providing certain types of training and educational and vocational opportunities for the defendant, to ensure that the defendant's sentence is in line with, is about the same as other defendants who have similarly committed the same types of crimes. So these are factors, statutory factors, that the sentencing court has to consider before imposing whatever the sentence is, whether it's a sentence of imprisonment, or in some cases, they may impose a sentence that does not involve imprisonment, but may involve what's called a term of probation, where sometimes a person is under house arrest or has some other restrictions that are imposed that are also a sanction based on the fact that they committed a certain type of crime. The sentencing guidelines is really the intention of the guidelines. It goes through, it's a big book. We all have to use it. We all every time we have to look at the book and we have to make a calculation based on this manual, okay? I'm not going to go into detail about it because, again, it's not that important for purposes of talking about our system. But there is a United States Sentencing Commission that took every single crime and made kind of decisions, levels that we have to use. And it's almost like a mathematical calculation. And they made decisions about what the applicable range of imprisonment for each type of crime. So obviously more serious crimes, the range of imprisonment would be higher. Less serious crimes, the range of imprisonment would be lower. Would also take into account a person's criminal history. And there are other things that would be taken into account. Whether or not they hurt somebody in the process of committing a crime, whether they used a gun when they were committing a crime. So lots of different factors. But the purpose of the guidelines, though, is to provide uniformity among defendants and proportionality with respect to sentences. It is an advisory guideline, though, so it's not mandatory in nature. With respect to the imposition of sentence, I've talked a little bit about this already, which is that there are a number of things that the court has to consider. And George actually touched on it. We have the United States Pretrial and Probation Office. The Pretrial Office makes recommendations about limiting the restrictions or movements of a defendant who is facing proceedings before conviction, okay? That pretrial office may make a decision, this person should be detained, should be held in custody pending trial, or they may make a decision or recommendation, I should say, that there are sufficient monitoring restrictions that if the person were released, they believe that there were sufficient, again, kind of rules or guidelines that the defendant could abide by to ensure that people are kept safe and that they do not fail to appear for a court proceeding. So the other part of that office is the probation office. They will make their own separate recommendation as to what a defendant's sentence should be. And again, they will cover every aspect of a defendant's background, including personal background, family background, employment history, criminal history, work history, mental health, medical. They compile all this information. They interview the defendant to get that information, compile it, they put it in a report, and they give it to the prosecutor, the lawyer for the defendant, and the courts to consider. And at sentencing, the court will resolve any disputed facts or legal issues. It allows the defendant the right to make a statement to the court about what sentence that they think, the defendant thinks, that he or she should receive. And it also gives an opportunity where there are crime victims to give their position to the court as well. Ooh, let's go to federal prison. Nobody wants to go to federal prison. I just wanted to tell you, though, that under the Bureau of Prisons, the Federal Bureau of Prisons, we have 122 institutions within just the Federal Bureau of Prisons, which is different than every state also has their own Department of Corrections. So we're talking a lot of prisons here, a lot of jails. And we have varying levels of prisons, okay? And I mean, with respect to a prison, you may have a minimum level, a medium level, a high level, and that just depends on the severity of the crime and the term of the imprisonment that's imposed on a defendant as to which facility they would get assigned to. We also have specialized medical facilities, and we have specialized psychiatric facilities for people who suffer from mental health diseases that are so severe they cannot assist their lawyer in preparing for trial, or they show that they were not in any they did not have the mental ability to form the intent to commit a crime. And they're placed in a psychiatric facility. So for post-sentencing, similar here, you can appeal. And we also have what are called habeas petitions, which is if you're in prison and your time for appeal has basically passed, and you want to argue that your lawyer did a really bad job, or maybe the law has changed and you say, now the law is in my favor and I should get my conviction reversed or my sentence lowered. There is an ability for a period of time after a person is sentenced to be able to litigate that issue, to try to set aside their sentence or to vacate their sentence. So, lastly, now I say American jurisprudence, but really this is jurisprudence in every country that is doing a great job with judicial reform, that is honoring due process and rule of law. And Maldives is doing that. So when I was thinking about American jurisprudence, I feel like jurisprudence here in the Maldives is very similar, if not identical, to American jurisprudence. Because you all here, and the lawyers here, and the people who are passing laws, everyone in the Attorney General's office, the Prosecutor General's office, you are all seeking to make sure that laws are publicly promulgated. It goes through the Parliament, it's reviewed, okay? Entities, stakeholders are given an ability to comment on that before laws are passed, or maybe not passed, that they're equally enforced regardless of what your background, how much money you make, where you came from, which island you lived in, how many years of school you had, how much money you have. It's equally enforced. It's independently adjudicated. So you have an independent adjudication by the courts here, and that it is consistent with international human rights principles. And Maldives is in the forefront, and many of the countries here in South Asia is in the forefront of becoming members of international conventions and international treaties, and I really applaud, for all of you who are going to be doing this work when you graduate from school, for all of you here who are already doing that work, I really applaud you for that. So that's what I'm going to end on. I know I went way beyond probably what I was allotted to speak on. I just got so excited when in hearing from PG Shamim and the history, the really rich history that he discussed in terms of leading to where we are. And I was like, God, I really want to tell everyone here that that rich history is what drove the United States to improve our system as well. So I want to thank you all for giving us the opportunity to be here and to speak with you. I hope we have a chance to come back in the future if you let us. It's really up to you, okay? And if I come back, maybe we'll see more people in this auditorium, right? And so I'm going to just hand it over to Anita to probably open it up for some Q&A and some any closing remarks. But thank you again for giving us the privilege and the honor to speak with you.
Thank you very much for the opportunity given to us. I have 4 questions, right? That is from Mrs. Wen, right? I have noticed that the procedures carried out in implementing the criminal justice, right? They are in America and Maldives almost the same, right? Similar. So my question is actually, the first question is regarding the bail system, right? Criminals arrested under the Terrorism Act or under terrorism crimes, do you accept any sort of bailing or any bailing? That's the first question. And the second question is regarding the investigation in criminal justice. Do you allow public or private investigations in your justice system? Thank you very much.
The standards for bail with respect to terrorism crimes are theoretically the same as they would be for other crimes, which is to say, yes, a terrorist defendant in the United States does have the opportunity to apply for bail. Does that happen? No, not very frequently, because most terrorists are considered too great a danger to the community to be allowed out of jail before trial is complete. So even terrorists in the United States have due process rights. They have all of the rights that are guaranteed under the Constitution. But because of the severity of their crimes, it is very, very, very rare for a person charged with a terrorism crime to be walking the streets pending trial. I think the second question that you had was, could you remind me? Private. It depends on what you mean by that term. So we have private investigators in the United States who are often retained by defense counsel to review the government's case, to dig up their own evidence that might be helpful for the defendant. That is very common practice in the United States for defense attorneys to hire their own private investigators. However, if by that question you meant to ask, can private entities bring criminal charges in the United States? The answer is no. So a defense attorney and their private investigator can do as much investigation as they want, but the decision whether to charge a crime in the United States is vested in the prosecutor's office and ultimately in the grand jury that must approve the charge against the criminal defendant. So there is no private attorney general that can enforce the law. Now, I put an asterisk next to that because the term private attorney general is a phrase that appears in under U.S. law, but that largely implicates civil cases where private citizens are empowered by the law to engage in civil cases where they are basically acting as a servant for the government in challenging the conduct of an entity or an institution, but those are proceeding largely under as civil cases, not criminal cases.
So I'll make one comment related to that, because I have learned about the role of the 241 committee, right? And we in the United States, we don't have a similar committee or group or government formed group where they conduct a parallel investigation during the criminal investigation. I don't know if that's kind of what you meant by a private investigation. It's not private because it's by public officials. But yeah, I mean, in that sense, we do not have that. We don't have something that follows along or is parallel and potentially adds to the criminal investigation. But certainly with private investigations, they would do it only to potentially file a lawsuit, okay? So one case very similar where it did happen was, everybody knows O.J. Simpson? Do people know O.J. Simpson? Okay. So during the O.J. Simpson criminal investigation, they also had private lawyers that were retained by the victims' families. They conducted their own investigation, and they subsequently sued O.J. Simpson, and they won that lawsuit, even though he was found not guilty in criminal court. Okay, he was found liable in a tort lawsuit for murdering two people. So that would be a private investigation, if that makes sense.
Good evening. I'm a student of Islamic University at Maldives, studying Bachelor of Shariah and Law. Actually, I have three questions. First question is for the whole panel members, and last question is specific for Brady. My first question is, in Maldives we are having judgment prediction, and in USA I think mostly it is prediction from juries, right? So in your opinion, which prediction would be fair to the victim or the defendant involved? Judgment prediction or from the jury's position? And my second question is, specifically it is stated in this presentation, we have to decide which field we will be like criminal or civil. So for a student who would like to be a criminal lawyer, so what is the importance things should be taken? And my last question is for PG, like Ms. Wood stated in some landmarking cases in USA. Is there, in your opinion, is there any landmarking cases in Maldives in criminal cases? Thank you.
I think we'll address the first question, right? So in terms of a jury system or what I think of as a bench trial, which is a judge-only system. So, I mean, there are pros and cons to both. So it's hard to say one is better than the other. I mean, certainly the jury system, the purpose of the jury system, which also lies in our Constitution, is that the decision whether or not somebody has committed a crime is made by a jury of their peers. That's the phrase. The jury is, they're hardly ever the defendant's peers, okay? And we want them to be diverse because we want them to be fair and not lawyers. We don't want lawyers making the decision. So they're actually instructed about the law that they have to apply, and they're supposed to be the ordinary layperson who makes that decision. And that is to be fair to the defendant. So that a judge, for example, who may have lots of experience, might already have some assumptions about a person's guilt or innocence. They're not supposed to apply those assumptions, but because they're very familiar with the law or they've been very experienced with the law, it may unintentionally apply those assumptions in finding a person guilty or not guilty. So, obviously, there's a jury system here. I don't think there's any discussion about implementing a jury system. That's actually, the minority in the world. But what I have found in working with other countries is a middle ground, which is a multi-judge panel. Because then it is slightly like a jury system, and you have more than one person making that decision, and that decision has to be representative of each judge's findings, or it has to be a majority, like 2 out of 3. So I think that's a model I think that could be discussed, and I know actually in talking with PG Shamim, it's allowed here, and it may not obviously he can address this much better than I can, but I know that it is possible here, and I think that that's a good system to think about implementing on a more consistent basis.
I would just add to that one thing, which is that when our Constitution was enacted in 1789, the amendments were ratified at around the same time, and there was intense suspicion of government by our founding fathers. And so, ironically, the Constitution of the United States is often thought of as a very positive document from which rights flow. But it was designed as a document that limited government power. And one of the reasons why the jury system has been enshrined in US law is because every other player in the criminal proceeding is a member of the government and is getting their salary from the government. I'm a prosecutor, I get paid by the government. The judge gets paid by the government. Oftentimes the defense attorney is publicly appointed and is getting paid by the government. And so the founding fathers in our country at least thought it would be important that the ultimate decider about whether a defendant is guilty or innocent would not be a member of the government. It would be a person or a group of people drawn from a cross-section of society. So fundamentally, the jury system in the United States is just another example of a protection against the power of government. But I would I agree with Yiting that jury isn't necessarily better at weighing facts than a judge. I think these are things that are debatable, very much debatable, and certainly a judicial process that involves a judge is consistent with rule of law principles for sure. So that's all I would add on that.
Thank you. What I actually meant by focusing on one area is that because of the rapid development in the reforms, it could be possible for a lawyer to focus on or to understand all the issues surrounding any one area of practice. That's what I actually meant by focusing on one area. Then we got a comment to we are already tajribaan එන්න සුරතව ප්‍රොබ්ලම් කමකී වරන් අවහම් එක්සි කියන දස්තු. මේක බබුතන්නේ ඊයස් ආනසාසීකස් අර ගිනපහර කියුකොම්මි දිනා එස්ලා ගන්නස් අර ගිනපහර කියුකොම්මි අවහම් එක්සි කියුබා මේක ගුණා වාහකේ නැගයන්න දස්තුර. මේ උනර මේ ප්‍රැක්ටිස් කොම්පින් හොද්දේ උනර and aham ichi idalwa dastur abadus ichi idalwa denne vaahake dakwa kariya login to dakwa vaahake kariya login vaahaka dekkumun hei arutu nimme men ichi liuko biharusures liuko falta korama kortama liukkeni mara gosko mara dakko enna se ina liuko araka me faltawane ibarata daswane emasekke biharusure pattaya අරුණුතුන් මරණ අවහ බාර කුරිය වැඩන්නේ. යුද්ධගත ගෙන්න මුහිමකමකින් කියු ගාන විදාලම විහස් ඉරන් විහස් අවහක කියන දසුර ඒගොල්ලන් අතිසිපාගේ අරුන් විදන්නවනේ මගේ දායරාට තක්සීස් වහකේ නු එරනස් විහාරේ කුරියුන්ට ගන්න බොතුන් අරුන් පෙන්න මන්සරකී කුරියම තනක වල පුළුවන්නේ ඒකී දායරාතකුන් කුරිහා දායරාතකුන් තක්සීස් වහන්න පුළුවන් අරුන් මේ මසකතුගේ බාසාරංග මේ බදනී කාපතෝ එන්නේ මොළු ඊයේ කොම් කමකත්ත වෙලි විසාරක මේ දිනාය මස්සලේ ෆෝටෝ बनाना මොළු මියකී වෙන්නේ ආයෙ මස්සලේ වර්ගයවණේ කන්දේ මොළු මියකී වෙන්නේ එයි ඒ කමක බකි කමක මොළුකුම් එයි විහාර වික්කේන නර මේ ඒවා කරනවා
Do you mind repeating that? I couldn't only hear it part of it.
මාස් කරලා මේ තුන්වර බාර විදාලන නමවා
My question is, which of uniform or non-uniform sentencing is better?
It's a very difficult question to answer. And like a lawyer, I won't answer. The sentencing guidelines in the United States were enacted because there was a perception that defendants in certain parts of the country were getting much more severe sentences than other defendants in other parts of the country. And there was also the perception that defendants who may have who may be from certain minority groups or from certain nationalities were getting more severe sentences than people who were not from those groups. And so the guidelines were, the animating principle for the guidelines was a positive one, which is the government wanted to be sure that there was equity and proportionality and even-handedness in the promulgation of announcement of sentences. The problem was that there was a long history in the United States of judges taking into account being very sensitive to the unique details of each defendant's life. And the defendants felt like the guidelines, when they were mandatory, eliminated their discretion and required them often to impose sentences that were more harsh than they wanted to impose. So ultimately, what we did in the United States is we made sure that the guidelines were not mandatory, but the judges were required to at least reference them to see what they suggested and then use that as one factor in deciding what sentence should actually be imposed. So the problem with uniformity in sentencing is that not all defendants are the same. And that really, it's always going to be a struggle. So that's my thoughts on that issue. PG, want to weigh in on the U.S. sentencing system?
Our sentencing system is also influenced by the U.S. System. Instead of making it mandatory, we say that the judge has the discretion to move 2 steps up or 2 steps down, and that the judgment itself can be appealed at the High Court. And the reason that we came up with this sort of system is that we did not want the judges to feel that we are taking away their discretion, but at the same time, there was a huge variance on how we sentence people. And our criminal justice system initially, before the penal code, had historical reasons for some sentences. So the sentencing was not harmonized. So you see, you have a person who commits a crime who murders a person does not have a sentence in the penal code. It doesn't carry anything in the penal code. Whereas offense against the state is the first provision of the penal code. So you see where we are, the historical reason for the drafting of the penal code. It was drafted overnight, so you can imagine how this was done.